they weren't chosen by accident. Jurors in Disguise, a jury investigations podcast, exposes jurors who lied their way onto the jury to secure a guilty verdict. Each episode, owner and founder Mary Rose Peterson pulls back the curtain on real cases, revealing misconduct buried in lies beyond the gavel. Visit us on YouTube at youtube.com/@juryinvestigations.
Hello and welcome to another podcast of Jurors in Disguise. My name is Mary Rose Peterson and I own Covert Obster Investigations. Back in 2015, when we began investigating our jury and uncovering the fact that the foreperson had lied to nearly every question asked of her, I also came across this article about a juror who lied during the voir dire. I thought that this is how juror misconduct would be treated by the courts in our case. And then as I formed the company, I thought that this is what would happen in all of our clients' cases. But if you've watched any prior podcasts, you realize that our clients are consistently going back to court and being. This article is titled Juror and Wife Murder Case Criminally Charged for Mistruths About Her Background. 11 years ago, Marilyn Charlesworth filled out a jury questionnaire, checking no on 3 separate questions asking if she had ever been a victim of domestic violence or violence of any kind. Her check marks turned out to be lies. The lies set off a string of judicial events that reached all the way to the Colorado Supreme Court, caused a murder conviction to be thrown out, triggered a costly new 6-week murder trial, and ended with a rare criminal contempt of court ruling against this juror. Lawyers and judicial officials say Charlesworth's case is highly unusual, a real-life parable about the seriousness of jury duty. Quote, "It's a serious thing to make false statements under voir dire," said University of Colorado School of Law professor Christopher Mueller. Quote, "She put the system to a huge expense and a lot of unnecessary work by not being candid," end quote. Jefferson County District Judge Jane Tibble last week found Charlesworth guilty of contempt because her under oath lies about her domestic violence experiences were considered significant in the context of a trial about the ultimate form of domestic violence, the murder of the defendant's spouse. In 2004, a 12-person jury that included Charlesworth found Michael Blagg, an outwardly devout and devoted family man, guilty of murdering his wife, Jennifer. He was sentenced to life in prison without parole. Charlesworth's credibility as a juror became the focus of nearly a decade of defense attempts to overturn Blagg's conviction. At first, the public defenders representing Blagg unsuccessfully claimed that Charlesworth hadn't revealed that she is legally blind, which they argued could have altered her ability to see evidence. Later, they unsuccessfully tried to show she had lied on her juror questions when she said she had never used the anti-anxiety drug Xanax. The public defenders finally succeeded in having Blagg's conviction overturned because Charlesworth claimed on her jury form that she was not a domestic violence victim. The truth about her background came to light 2 years ago when Charlesworth spoke out at a Grand Junction City Council meeting as an advocate for abused women. I found this fascinating, how they found the juror misconduct. They weren't even looking for it. She was one of many citizens who publicly called for the resignation or recall of a then city councilman who had abused his girlfriend. Court records backed up Charlesworth's domestic violence history. She had sought restraining orders twice for protection from 2 abusive ex-husbands in the 1990s. In the petitions for those orders, she had described one husband, quote, smashing a beer can on her head, and another being threatening with weapons. One ex-husband was also charged with child abuse for a violent incident involving her son. Inappropriate juror for this jury? Absolutely. When her conflicting stories threatened to derail the Blagg conviction, Charlesworth told an investigator that she had lied to the city council about her background to make a point about abused women. Mesa District Judge David Botker didn't buy it. Good for you, Judge. Based on the false claims on her jury form, he tossed out Blagg's conviction last year. Finally, a judge that did the right thing. Thank you. 21st Judicial District Attorney Pete Houtzinger then filed a contempt charge against Charlesworth. That's what should be happening in all of our cases, but it's not. He said this affects all of us. There is a social cost to this. Charlesworth's defense attorney, Dan Schaefer, tried to portray her in the contempt hearing as a victim of misunderstanding. He previously had tried without success to have the Colorado Supreme Court review the legality of the contempt citation. Justices refused to intervene in this portion of the twisted Blagg case. The High Court had already issued an order in the case that forced a 3-day bond hearing for Blagg 2 weeks ago. In one of many unusual twists in the case, Judge David Botker, who had presided over the Blagg trial, became a prosecution witness in the Charlesworth case. On the witness stand, he debunked the misunderstanding argument by detailing how he had used Random House Dictionary definitions of the words domestic and violence to make that crime easily understood to potential jurors. He also described the many steps in the jury selection process when Charlesworth could have changed her answers to the question. Does this sound like one of my reports where I'm quoting the jury voir dire and all the times that the judge and the state and the defense asked the jurors, demanded that the jurors be truthful? Yes, it does. The state attorney testified, quote, "This conduct cannot go unpunished." You're right, it shouldn't. Judge Tidball agreed, and so do I. Why don't our judges agree? On April 29th, she found Charlesworth guilty of contempt and will sentence her in June. Rob McCallum, a spokesman for the Colorado Judicial Branch, said, quote, "I've never seen a case like this. Contempt is a tool the court really uses sparingly." Well, maybe they shouldn't. Maybe contempt of court should be something that is used frequently and liberally in our cases, for example, because that is what the jurors did. They lied to the judge's face. McCallum also noted that, quote, "The vast majority of people take their civic duty very seriously." Oh, please. I guess I need to have a talk with Mr. McCallum. If Mr. McCallum learned of our 120 plus cases where our jurors, one or more on each jury, came into the court and lied to the judge's face, I believe he would retract this statement. A Denver defense attorney and past president of the Colorado Defense Bar said other potential jurors should take note of this case. Quote, "It is outrageous for a juror to lie under oath. Such lies strike at the heart of the integrity of our jury system. They are a slap in the face to our whole judicial system." Yes, I would agree they are. So why is it that the state of Florida doesn't seem to care? Why is it that the state of Florida is not holding them accountable? And why is it that the state of Florida is going to such great lengths and such ridiculous using such ridiculous excuses to deny the motions? Could have found it sooner with due diligence. Who is looking? Nobody. The defendant's in prison. He can't look. He can't search for juror misconduct. He doesn't even know he's supposed to. No access to internet, no ability to request or pay for public records, no lawyer to help him. How's he supposed to find juror misconduct? That's absurd. But that is what our judges are saying when the motions. It would be laughable if our clients weren't in prison. It's impossible. But that's what they're saying on paper. And they say it with a straight face. Dan Schaefer, the attorney for Charlesworth, the juror, could not be reached for comment. but stressed in the hearing that at the time she served on the jury, she did not view herself as a victim of domestic violence. Well, she certainly did when she filled out those injunction papers. She said she was a victim. He said it is clear now, 23 years later, that it was domestic violence, but she didn't get counseling or confide in friends when it happened. She called it domestic violence for the first time in 2013, Schaefer said. Well, that's not true. She filled out an injunction for protection against domestic violence. So you said it was domestic violence when you filled them out. That's another lie. Charles Worth has told Grand Junction media outlets that her abuse took time to process, and she simply did not understand at the time of the Blagg trial that she was a domestic violence victim. She said that she is clearly a victim now of the judicial system. Seriously? Are you buying this? Because I'm not. That leads me to my next point. We just concluded a case. I wrote a report, and I've labeled all of the exhibits. Exhibit A. Well, the report is 22 pages long. I have Exhibit A through Exhibit W. Those are the exhibits. I'm going to read to you some of the things that the judge said to the prospective jurors. The judge said, "Welcome, welcome, welcome. Please be seated. Good morning, ladies and gentlemen. I am the judge in this division, and you have been called up to be potential jurors in a criminal case. The state of Florida, this is a criminal case. It may be that you're not suited for this case, and this is a big issue, a heavy issue. It evokes a lot of emotions and a lot of strong feelings. And so, maybe that you were the victim of a crime or the loved one was a victim of a crime, and you just, can't see straight on a case like this. Or maybe you were falsely accused, or someone in your family or loved one, or you were mistreated by law enforcement, and you just don't feel like you can be fair and impartial to law enforcement. That's okay. Those are experiences that people have, and those are feelings that people hold. And during this process of jury selection, when we're asking you questions, please answer our questions frankly. Just be truthful. And don't worry about whether we feel your answer is right or wrong. You don't have to defend your answers. You don't have to justify them. And just let the chips fall where they may. But if you're not well suited for the case, you might be well suited for a different type of case. So, know that we're looking for, I'm looking for a group of what we call fair and impartial jurors. That's kind of the phrase we use here, fair and impartial. And what I mean by that is I want a group of jurors that are not going to go rooting around for an outcome at the beginning of the case. They're not hoping the state wins, and they're not hoping the defense wins. Judge says, I want a group of jurors that just come in with a blank slate as it pertains to these facts and these allegations and think, I want to figure out what the state's trying to say, what they think happened, and hear the evidence. And after you've heard all the evidence, you decide the state, did they prove their case or not? And if they didn't prove their case, then you're encouraged and courageous enough to say, not guilty. And so that's the kind of jurors I'm looking for. And that's what this process is meant to go through. Give your answer, speak your truth, and let the chips fall where they may. There's no right or wrong answers to these questions, and you don't have to feel bad about it. This is the way I feel, and even if it's politically incorrect, so what? How many of you, when you got your summons to come down here and to serve as a potential juror, thought to yourself or said out loud, great, I'm excited. I can't wait to go down to the courthouse and be on the jury. Let me see. Oh, come on. Anybody? Well, how many of you, when you got that summons to come down here, thought to yourself or said, oh man, I don't want to go down there. I'm going to miss work. This is going to interrupt my life. And then you start talking with your friends about how to answer the questions to get out of jury service. Half of the jury raised their hands and said, yep, that's me. Didn't want to be here. All know that you're smart enough to figure out ways to answer these questions and get kicked off the jury panel or get selected. I put that in there. You get that. He said, that's not difficult to do. That's very easy to do. And I don't want to put you through that farce. Serving as a juror is the most important and vital service that you as a citizen can perform for your community. Palm Beach County, state of Florida, the nation. It's the most important service that a citizen can do other than fighting in a war. And that's hard to believe. That sounds huge. It's hard to grasp. And it's true. It's exactly that true. And here's why. At this point, the judge became serious, and all I could think about was to cue the Yankee Doodle Dandy song. He said, for over 200 years, citizens, our ancestors, your parents, your grandparents, your great-great-great-great-great-grandparents, for decade upon decade, century after century, have been going to courthouses across every county in all these states across the United States for as long as we've been a nation. And it is that process. It is their participation. It's your participation. I got called down for jury duty once. I didn't get picked. No surprise. But it is your sacrifice, and it is a sacrifice. I know that you are all sacrificing. Some of you are going to get paid while you're down here. It's going to be, at the very least, inconvenient. But it is a sacrifice that keeps the system honest. What an interesting choice of words. Honest. Now, it is very important for you in this particular case, especially to the defendants, to resolve this dispute between the state of Florida and them. But in the bigger picture, if it worked for you coming down here, not only watching us work, but actually participating in the decision-making process, making the difficult decision guilty or not guilty, it is that participation that keeps the system honest. There's that word again. Because if it weren't for you, if it weren't for us, if it weren't for the citizens coming down here, these decisions would get made. These cases would get resolved, but you might not like the way it gets done. It might not be by bureaucrats. It might be behind closed doors, subject to suspicions, subject to abuse. What do you think he means by that? And it is because citizens come in and watch and work and make the decisions, it is what keeps this system So this trial, at the end of the day, is going to be one more brick in this stable democracy that we have all enjoyed because of our forefathers, our ancestors, and those that have gone before us. If you do end up serving on the jury, you will forever have a very well-informed opinion on what happens down here at the courthouse. When you're sitting at the dinner table or at a social setting, you can talk with your friends with intelligence about, here's what I like about the system and here's what I don't like about the system. You will be well advised and be able to offer fair criticism. So I hope I share all that with you to hopefully empower you to make you feel like this is worthy of your sacrifice, and that to thank you in advance, to thank you so much for your sacrifice, because I appreciate your sacrifice that you're making, and I hope you find it worthy. I hope you do. So there you go. That's my patriotic speech. Think he meant those words? Oh, we'll find out. What the judge said next actually surprised me, because it's the first time that I've heard a judge talk about the Bill of Rights. He said the right to remain silent is a right that comes to us from our Constitution in the Bill of Rights. It's a right that we all have, but it only really comes into play during these criminal prosecutions that get tested. And what it means is that, to us, is this. During this trial, the defendants might testify. They might, choose to testify, or they might not testify. They might choose not to testify. And whether or not they do is none of my business. And perhaps they and their lawyers haven't even made that decision yet. But if they choose not to testify, you can't hold that against them. He said you can't draw that conclusion, the conclusion that he must have done it because he didn't testify. That's inappropriate, and here's why. I think that's kind of for two reasons. Well, one, the law says so. It's his constitutional right not to testify. And if we have a right and then we allow jurors to hold it against them, if they exercise that right, well, then we haven't given them anything at all. We've taken a right away from them. Why is it then that every time one of our clients goes back to court, showing to the court through my report and our exhibits that the juror or jurors came in there and lied to the court's face? Why is it that suddenly the defendant's right to a fair trial by an impartial jury doesn't matter? Why is it that judge after judge after judge says, do you think the judge meant that? All those words? The patriotic speech? Do you think he meant them? Well, we'll find out. Thank God my husband's home. Our client Ravis Williams is home. And we have quite a few cases still fighting it out in court, still reopened. We're waiting for those judges to do the right thing. Follow your own rules. I had a friend who passed away recently, but he was with me all through Martin's case. He was a career politician, and I have lost track of how many times he would look at me and smile and say, you do the right thing because it's the right thing to do. I wish that all of our judges felt that way. And I pray to God that one will. Thank you for watching. Remember to like and subscribe. And share these podcasts so others will know what's truly going on in courtrooms across America. Remember, the courtrooms may be silent, but we won't be. We will speak up, we will speak out, and we will always speak the truth. That's all for now. God bless.
All it takes is one to convict an innocent person. One Trojan juror, one biased agenda, one hidden motive. That's why we investigate juries. We identify the sinister players and expose them. Jury investigations. Our number one objective is to get you back into the courtroom, because a guilty verdict doesn't have to be the end of the story.